Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Amanda Hamilton, and today we'll be discussing, is there a new playbook for merger remedies? Antitrust enforcers have grown increasingly skeptical of merger remedies. They've expressed doubts as to whether remedies resolve a merger's competitive issues and have been more willing to challenge a merger in court as a result. We saw this skepticism reach new heights during the Biden administration when enforcers took a hostile stance towards remedies. While Trump Vance antitrust enforcers have retained the skepticism towards remedies, they've also expressed a willingness to discuss and enter settlements to avoid costly litigations. During today's episodes, we'll learn about the trends and process and remedies that got us to this point, the Trump-Vance administration's approach to merger remedies, and practical advice for proposing remedies considering the current landscape. Joining me today is my co-host, Jaclyn Phillips. Jaclyn, who is our guest today?
Thanks, Amanda. Our guest today is Milbank partner Adam Vincenzo. Adam is a partner at Milbank whose practice focuses on representing clients in government reviews of mergers, acquisitions, antitrust investigations, and antitrust litigation. Adam leads matters for a wide range of clients, including Fortune 500 public companies and private equity sponsors in their portfolio companies, and in a range of industries spanning energy, retail, media, transportation, and more. Adam, welcome to the show.
Thank you for having me.
Let's start off by discussing the role merger remedies play in merger review. And what does the evolution of that merger remedy process over the years tell us about what enforcement concerns might be with merger remedies and how those concerns impact the approach to merger remedies?
Sure. So merger remedies have played an important role in merger review as long as there have been mergers and merger antitrust enforcement. At the front end, parties, of course, file HSR on sizable deals with the DOJ and the FTC. The DOJ and the FTC will review the more problematic deals that raise issues of concern during a second request. And at the end of that process, in most cases, the parties and the agencies negotiate a remedy. And that remedy will address any lingering concerns that the agencies have identified during their investigation. At the DOJ, there's a special process under the Tunney Act to negotiate and memorialize the remedy that is then blessed by a court. The FTC follows a different process through its own internal procedures. And the remedy has the benefit to both the agencies and the parties of avoiding costly and uncertain litigation, which might be good for both sides in the sense that the agencies save litigation resources, which can be scarce, and the parties have the certainty of getting to closing. But of course, agencies have developed merger policies over time. And over the past 10 years or so, we've seen quite a bit of change in how agencies review mergers and how parties go about them. And before, I'd like to say 10 years ago or so, we had a pretty predictable process when it came to especially structural remedies. Structural remedies are remedies that involve the sale of a business or sale of assets that are usually a remedy for a horizontal deal, a deal between two competitors, and competition is, of course, extinguished between those two competitors. And up until about 10 years ago, there was just a wide consensus among merging parties and enforcers, both in the United States and abroad, that remedies were a good thing for the reasons that I mentioned before. They could save the agencies and enforcers resources, and meanwhile, they could save the merging parties the uncertainty and costs of litigation or additional proceedings if you're outside the US. And a lot of this came from changes in the way that antitrust enforcers thought about merger enforcement and whether remedies themselves were adequate to address perceived competitive harms that might arise through horizontal deals and through their close cousin vertical deals. We also had some high-profile merger matters where critics pointed out to flaws in the effects of settlements. So one infamous example is Hertz and Dollar Thrifty, which happened in 2013, about 4 months after the parties divested assets in the rental car business to a new company called Advantage. Advantage had to file for Chapter 11 bankruptcy. And that was obviously a failed remedy because you did not restore the competition. You didn't have a competitor there that was as strong as the merging parties were before the deal. But you've also had deals like Ticketmaster Live Nation, which was a consent decree entered in 2010. And over the course of the last 10 to 15 years, you've had many critics of the industry that have pointed to the merger, and the settlement, which at least to some did not work as anticipated. And so with that criticism came a series of new administrations which have tried to address fundamentally whether remedies were adequate, were the right path to resolve a particular merger. And we saw this start during the first Trump administration. It really accelerated and intensified the skepticism of merger remedies, that is, as a fix to merger problems. And we have seen that in some form carry through to today, but we've had a lot of change. And as I mentioned, during the Biden administration, the DOJ, led by Jonathan Cantor, took the view that merger remedies were almost never an adequate outcome, and that a simple injunction was the preferred outcome because it should be up to the parties to propose a deal in the first instance that did not, in its view, substantially lessen competition in violation of the antitrust laws. And so the DOJ for 4 years virtually never engaged in remedy negotiations and left it to the parties to fix the deal, or if they failed to fix it, or the agencies had other issues with the deal, they would file a lawsuit. And so we saw not only the abandonment, at least at DOJ, of the consent decree process, but we saw more litigation. And we saw litigation over what fixes would be sufficient and which fixes wouldn't. One of the benefits of that litigation was that we learned a lot about what the courts think about merger fixes, and not only what the scope should be, but what types of fixes fix which types of mergers, and whether the timing of the proposed fix matters. And so we have learned a lot, and now we're embarking with a new administration that now has an even different approach to merger fixes than we've seen in the past.
Got it. Thank you. It's a very helpful background. And just before we dive into what the current process looks like, does the trend that you identified for structural fixes apply to conduct remedies?
Sure. So it's a little bit different with conduct remedies, and we definitely see some important trends with conduct remedies. It used to be the case that the FTC and the DOJ would regularly enter conduct remedies. So conduct remedies are remedies that involve not structural fixes, not the divestiture of ongoing businesses, but the entering of contracts, the entering of a consent decree, which restricts the actual conduct of the merged business going forward. And they were most common in vertical mergers between a supplier and a customer. So an input supplier and a customer would enter a merger. The theory of harm would be that now the new company would have the incentive or the ability, or both, to cut off competitors, either upstream or downstream. And therefore, when it comes to conduct remedies, the way to fix it would be to enter into a long-term contract that was subject to a consent decree that would set the commercial terms on which the parties would deal with their new customers who are also competitors. And over the course of the last 7 years, in addition to seeing a lot of litigation on horizontal mergers and fixes, we've seen a historic number of litigated vertical cases. And in the context of those cases, the courts have weighed in on what types of conduct remedies are appropriate and which might not be. And so we've learned a lot about what conduct remedies work and which don't. And one where we are, I think, today is we have a contrast in the way that the courts and the agencies look at vertical conduct remedies. Vertical conduct remedies are still seen by the agencies. They're viewed through a lens of skepticism. They're very hard to get accepted even at the agencies today. But courts have voiced a more willingness to accept conduct remedies and accept long-term contractual commitments in the context of vertical cases that they're reviewing. We saw this in the Tempur-Pedic merger case. We saw this in AT&T Time Warner and in Microsoft Activision, all of which involved commitments by the merging parties to engage with their competitors on specified terms for a long period of time. And the courts were far more willing than the agencies to accept those.
We've discussed where we've been, what courts have said, and now let's just bring us to current times. So we have Trump Vance enforcers in, we have Chairman Ferguson at the FTC, we have Gail Slater over at DOJ. What have they said about merger remedies?
Sure. So now we are once again revising our remedies outlook and playbook because the new administration has taken a decidedly different course with respect to remedies than the administration of the Biden administration. And that mainly is a much more open and willing tack towards merger remedies that are proposed by the parties. Both Chairman Ferguson and AG Slater have said that it is their job to challenge those mergers which pose real competitive problems, but then get out of the way, literally get out of the way when it's necessary and practical as a way to avoid expending scarce resources by the agencies and also to allow otherwise pro-competitive mergers to move forward. And so what AG Slater has said and done in practice is that parties should come to the table with strong remedies that meet many of the traditional indicia of remedies that the agencies are willing to accept to address the competitive problem. And that is a very different tone than we saw from the prior administration, where going into a merger, the assumption was that the agency would not engage in those discussions. We've also seen a greater willingness at the FTC to engage in remedy discussions. At the same time, however, and I should note this as a word of caution for clients and merging parties, and that is that the agencies still are taking a quite hard line towards structural and conduct remedies. And so they're still willing to go to court, as they have in some cases where the proposed remedy, in their view, was inadequate, fell short of the mark. And so that we're still not in a world where we can expect to settle every case, but we certainly are seeing more settlements than we have in the past.
So AAG Slater and Chairman Ferguson have both entered into several merger settlements during their tenure. What do those settlements signal about the types of cases they're willing to settle?
So it's interesting. I think we are seeing a broader array of types of remedies than we might have seen in the past for traditional horizontal mergers. And it's still early going, and we still have a long ways to go. But for example, in HPE Juniper, we saw a licensing remedy as part of an overall structural fix where the DOJ was willing to license or allow the parties to license software to a competitor rather than to sell a business outright. And that's unusual because in the past, even 10 years ago, the agencies were very reluctant to allow for transactions to settle when there were ongoing entanglements between the parties. The concern being that a license remedy might be something that the agencies need to police. There are different ways in which software patches and software updates might not be available to the new competitor. And you can see how there might be incentives by the merging parties to perhaps not provide all of the latest and greatest software updates to a rival. And so for that reason, there was a lot of skepticism. And of course, every merger is different, but I thought that was notable. We also saw a merger fix in the Omnicom advertising deal, which involved the a consent, a conduct remedy on the merging parties' dealings with advertisers. And it was essentially a promise not to discriminate against advertisers for their political viewpoints. It isn't a conduct remedy for what ostensibly was a horizontal concern. These were two advertising agencies that competed with each other. And it's been a while since we've seen a conduct remedy that either agency has agreed to as a fix to a horizontal deal. So there have been exceptions to the rule, but we also have seen more settlements. We saw the DOJ settle United Health and its merger with Remedies, and along with other settlements that we haven't seen in the past.
So it sounds like Trump antitrust enforcers are willing to be a little bit more creative with their divestiture or the settlement terms. And have these settlements said anything more about what they're looking for in terms of the divestiture package or buyer, to the extent that it's applicable?
Sure. I think the FTC in particular, and Andrew Ferguson in particular, has been pretty clear about what the FTC at least is looking for. And they're, of course, looking for strong buyers who are willing and able to carry on the business. But they're also looking for settlements that involve assets that are what I call severable, that are clean. So oftentimes when you have a business that's part of a large corporation, sometimes that business can be very integrated with that organization, and that can make a carve out much more complicated. And it's not just a corporate matter, it's also, in some cases, at least according to the agencies, a competitive matter, because if you have people that are being brought in from all parts of the corporation and sort of cobbled together to form a new business that hasn't operated as a single business before, that can, in the eyes of the DOJ and the FTC, make it less likely that that business would succeed as a competitor. And that's ultimately what the FTC and the DOJ want, right? So I think the FTC and the DOJ are much more focused on finding fixes that involve clean divestitures where you don't have all of these ongoing entanglements and the cobbling together of different assets.
Super helpful context. And now what people might be thinking is, what do I do with all of this information and this knowledge that things might change over time? So from your vast experience doing deals, what are some best practices for proposing remedies to antitrust agencies when you're in the middle of a merger review?
So great question, because there are a lot to it. And I'm going to unfortunately answer your question with a series of questions, because I think through experience, what I've learned is it's really critical to ask the right questions of your client, because ultimately the decision to divest or the decision to even offer a remedy is not an easy one for clients, especially if you are representing a client who is public and has to announce that the deal has changed and has to do that before the DOJ and FTC have perhaps accepted the settlement, and you have deal certainty as to when the deal is going to get done. And so what are the three questions that I always like to start with? And the first is, as you might imagine, how strong is my case that the deal should proceed without a remedy? So when I'm looking at all of the evidence, and me and my team and the client are together in this, along with the other party, what do the documents look like? What does the economic analysis look like? What are my chances if I go to litigation and try this case of getting the deal done without an injunction intact? And obviously there's a conversation to be had with the client, is how important is this business to you, to realizing the synergies of the deal, or not? But I think that's one question that it's good to know the answer to that as soon as possible, rather than at the end. Because if you know the answer to that, you can plan out your deal process. Even if you don't propose the remedy right away, you know in the background that there are ways that you can pitch the deal to the agency, depending on whether a business is going to be sold or not, or whether you're going to propose that or not. And also you can counsel your client on what the risk is, that if you go to litigation, that the entire deal will be enjoined because of this one area of overlap, whereas the rest of the deal is not problematic. And those are important questions to answer. The other question I like to ask, and this might be obvious, is how strong is the remedy itself? So Typically, there are multiple options available to fix a problem in a horizontal deal or in a vertical deal. By definition, in a horizontal deal, there are usually two options. You can either sell the seller's business or you can sell the buyer's business. You don't need to sell both. And typically, what clients want to do for obvious reasons is sell the smaller of the two businesses. But selling that smaller business might be harder to sell in turn to the agencies. And you might need to do more work to convince the agencies that selling the smaller of the two businesses, while removing the overlap, might have flaws that the agencies point out to you. So, for example, if one of the businesses has real entanglements with one of the parties, if there's IP that can't be easily untangled, there are employees that work in multiple businesses and can't just go with the business. All kinds of entanglements, part of some of which we talked about before, might make that remedy less saleable. And so the strength of your remedy, how easy it is, might counsel as to when and on what terms you offer it, because just like your strength on the merits, whether pushing forward or not is a good idea. And the third question to ask yourself is, what are the pros and cons of proposing a remedy now? So you know what the merits look like, you know whether you have a strong remedy or a weak remedy, but are you likely to get benefit from proposing a remedy early versus late? So I've seen remedies proposed at all stages of the process. Sometimes you see remedies baked into the deal itself. So sometimes you have a company sell business A to a third party in order to remove the competitive overlap that would otherwise be part of a larger deal before HSR is even filed. Sometimes you propose a remedy relatively early on before you're finished with the second request, because having seen your documents, having done the economic analysis, that your chances in litigation are slim, or you might be highly doubtful of whether the judge is going to go your way, and you might get lots of process benefits from taking this off the table. If it's the only area of overlap, you think you have a relatively weak case on the merits if you were to go forward with litigation, and you have a strong remedy, that might counsel again in favor of offering an early remedy, because then you I think stand a fair chance of convincing the regulators, the enforcers, that we ought to narrow the second request, we ought to get this done, and your client can close the deal sooner rather than later. On the other hand, if you've got multiple problems, if you've got a fix for product A but not a fix for product B, and you know you're going to be in it for a long time on product B it might not make sense to offer that remedy right away and to continue to advocate, because again, offering the remedy is essentially a concession that there is a problem. And it's very hard to unring that bell once you make that offer. And so that can be a hard decision on timing. The one thing I will say, and I think this is important, and Sheriff Ferguson has talked about it, is when you get close to litigation, if you think that a lawsuit is coming, you're at a decision point as to whether to offer the remedy or not, or to whether to make your best and final offer. Because once the remedy is offered, or not offered, once the lawsuit is filed without a remedy, then you're going to have a third party also looking at the remedy, and that is the judge. The judge is going to look at the remedy alongside the agencies and take a very close view. And so it just might be more complicated at that point to get a remedy done. But then again, you might feel that your chances in litigation are better. Personally, I think you want to be in a place with the agencies where you're at an impasse. You have done everything you can to try to get to a remedy that both sides can agree to, and it hasn't happened. That's when you go to litigation. Where you shouldn't be is just not communicating with the staff and the agencies. Communication is always a good thing, at least knowing where they stand and where you stand, so you can counsel your client and potentially avoid litigation is the best place you can be.
In situations where you're getting a deal through multiple enforcers, for example, in different jurisdictions like US and Europe, how do parties coordinate remedy negotiations between the different global enforcers reviewing the same deal?
All right. So great question. Again, juggling multiple enforcers and trying to solve a merger investigation is is really a high wire act because every one of the 120 or so jurisdictions around the world has its own process, its own timeline for evaluating remedies, and they may not align with where you are in the United States or elsewhere. While the answer depends, I think, again, the key is to communicate with all of the stakeholders. So if you involve one regulator in remedy discussions, I think it's important to start talking to the other regulators about what you're doing, even if they're not at the stage in which they can consider a remedy, either legally or otherwise, because it will help build in to what comes later in the process and will help speed along the process elsewhere. The other thing to do is, if you know you're going to implement a remedy globally from the beginning, you'll want to make sure that your schedule, your timetable for getting your filings in aligns with that. You want to be as close as possible in sync with all the different jurisdictions. If you reach a good result, a resolution in one jurisdiction, you want that to carry over and benefit you and others, so you don't have to keep having the same negotiation over and over again. And overall, you want that process to be shorter. Obviously, you've got to be sensitive to different market realities in different jurisdictions. The market in Europe may be fundamentally different than it is in the United States, and sometimes that will require additional work to bring the regulators around. But it's just something that has to be planned early on, which is why answering these three questions: do I have a problem? Do I have a good fix? And what are the pros and cons of proposing it now? Answering those three questions early becomes really important, not just for the United States, but for elsewhere.
Thanks, Adam. So now we're going to switch to a more fun section where we're going to get to know you a little bit better. Tell us something about yourself that people don't know if they just know you professionally.
Sure. Well, I spend a lot of time coaching my kids' baseball team. So, on the weekend, you'll find me driving in the hinterlands to different baseball fields, and occasionally maybe in baseball pants and full-on baseball uniform on the side in the dugout, or coaching third base. And it's one of the fun things I like to do.
Is it a travel team?
It is. I've got two of them, and house teams, and my daughter's softball team. So fully engaged.
Yeah, definitely.
We just moved from T-ball to a regular little league. So going from two days a week to 3 days a week. And that's been a big shift, but it sounds like there's more days a week in the future.
There's more fun in store for you in the very near future. But enjoy it.
Thank you, Adam, for joining Jaclyn and myself to discuss merger remedies, and thank you to our listeners for joining us.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.